Nagsimula na ang pagdinig ng House Justice Committee sa impeachment complaint laban kay Chief Justice Maria Lourdes Sereno. Tinatalakay sa pagdinig kung sufficient in form and substance ang dalawang reklamo ang inihain laban sa punong maestrado.
Ang una ay inihain ng grupong Volunteers Against Crime and Corruption o VACC at Vanguard of the Philippine Constitution, habang ang isa naman ay inihain ng abogadong si Larry Gadon. Inaakusahan si Sereno ng culpable violation of the Constitution, other high crimes at betrayal of public trust. Mga kapuso, panoorin po natin ito.
As public documents yet because being deliberated. So yun po yung objections ko. So yun pong, therefore, kung August 15, 2017, nilabas ng Supreme Court ang mga dokumentong yan, pero nakagawa na ng complaint si Attorney Gado noong August 2 at final niya na agad, sigurado ako na karamihan ng sinabi niya ay either wala siyang personal knowledge, hindi based sa authentic records, or public documents. At kung gusto po natin ng specifics, sa pagbinasa po ninyo yung complaint, karamihan po ay reference to news and opinion articles and not on the document that was explained to us or narrated to us by the majority leader, like yung committed culpable violation of the Constitution when she falsified the RO of the SC in GR number 206844-45. Kung gusto niyo pang mag-enumerate ako, meron pong 11 allegations na based lang po on attached newspaper clippings. That's why I am objecting to the complaint filed by Attorney Gadon based on form.
Sige po. Anyway, nandyan po si Attorney Gadon. Any member may ask him. But for the record lang, of course, we are just discussing the form. And then more importantly, dun sa proseso po natin ay kinukuha rin po natin yung verification when they go to the Secretary General. So he may have his own sources, but at the end of the day, what is important is when it is filed before this committee and or before this House, nandyan po yung mga dokumento na yan, at yan po ang pagbabasihan natin in determining whether there is sufficiency in form. So, we now go
Mr. Chair, let me just share what is a verification contemplated under Section 4 of Rule 7. It says a pleading is verified by an affidavit that the affiant has read the pleading and that the allegations therein are true and correct of his personal knowledge or based on authentic records. Clearly, Mr. Chair, authentic records are in our possession.
Precisely. So, yan yung ating... Nasaan na yung next list? Yun yung... that is the whole point, no? We now recognize Congressman Lagman to explain his objection.
Thank you, Mr. Chairman. Let me preface my objection by reiterating what the Integrated Bar of the Philippines said. The IBP said that the 1987 Constitution jealously protects the judiciary since it is considered the weakest of the government's three main branches. It further said, impeachment is a scalpel, not a broadsword. And even if it were the latter, no sword retains its sharpness if swung too far and too often. This has reference to the simultaneous pendency of impeachment complaints against the Chief Justice, against the Chairman of the COMELEC, and possibly against the Ombudsman. And the rules of procedure in impeachment proceedings as interpreted and applied by the Committee on Justice with respect to the sufficiency of form and substance with respect to the impeachment complaint of the Honorable Alejano versus President Duterte should be employed with the same efficacy and fervor. in the impeachment complaints against the Chief Justice of the Supreme Court. What is good to liberate President Duterte should also be good to liberate the Chief Justice of the Supreme Court from these impeachment complaints. And it should be recalled that during the impeachment proceedings before the President of the Philippines, repeatedly the leadership of the Committee on Justice said that in determining sufficiency in form, the complainant must have personal knowledge of the allegations in the complaint. It even went further in saying, and I quote, let the person with personal knowledge be the complainant, and to let a member of the House endorse the complaint. Since, according to the Committee on Justice, the Honorable Alejandro did not have any personal knowledge of the allegation in his complaint, then the complaint must fall under the scrutiny on sufficiency in form and substance. Now, let me go to the complaint of Attorney Gadon. In charge number 4.4, delayed action on the numerous petitions for retirement benefits of justices and judges and surviving spouses of justices and judges, he has no personal knowledge.
Please wind up, Your Honor.
Well, I have to abbreviate all of this. These are so numerous instances in the complaint where the complainant has no personal knowledge. But let me zero in on charge 7.6 on vacancies in the Supreme Court, charge 7.7 on the appointment of the Chief Justice of the PMC, and charge 7.8 on the grant of travel authorities and allowances. All are all, quote, matters pending deliberation and determination, unquote, by the Supreme Court itself. This is why the Supreme Court, in its 15 August 2017 resolution in AM number 17-08-05-CSC, denied Gadon's request to be furnished with Associate Justice De Castro's 10 July 2017 memorandum, which allegedly supports these three charges. Since these charges are pending with the Supreme Court, then they cannot be used in the complaint, and the complaint will have no sufficiency both in form as well as in substance. There are other allegations where there is no sufficiency in form and substance, but because of the limited time, I will have to discuss this most probably on a second round. Thank you, Mr.
Thank you, Your Honor. Let me just emphasize that, the complaint before us now is far different from the Alejandro complaint because in the Alejandro complaint that we tackled in May of this year, last May of this year, Congressman Alejandro was the complainant. But in this particular case, and he is a congressman, and he also effectively acted as an endorser, although there is no need for that endorsement because he is the complainant himself. But in this particular case, we have a private complainant in the person of Attorney Gadon, who did his homework while he may not have personal knowledge, he appended to his complaint authentic records. And that is what is lacking in the Alejandro complaint. So we cannot treat these two complaints similarly because the circumstances are different. And again, let me emphasize that the verification does not limit it to personal knowledge. It also covers facts based on authentic documents. And what else can be more authentic than a resolution issued by the Supreme Court where all the factual antecedents of those allegations will be contained therein, and the Justice Committee is not precluded from calling them in as witness for purposes of validating these facts for purposes of prosecution at the appropriate time, if and when this committee will vote upon a sufficiency and form and substance and even of probable cause. So we now call...
Mr. Chairman, I first limited myself to personal knowledge. I was going to so-called authentic documents, but because of lack of time, I wasn't able to pursue this particular issue. But definitely, newspaper clippings by any evidentiary standard would not be considered authentic documents.
Thank you. Now we recognize Congressman Villarin on his objection.
Well, thank you, Mr. Chair. Again, I would like to cite the Section 36 of our Rule 130 with regards to personal knowledge. And this refers to those facts or information that are derived from one's own perception, and not that knowledge derived from secondary sources do not constitute personal knowledge and are therefore considered hearsay. Now let me go, Mr. Chair, to a specific instance in this complaint of Attorney Gado. Well, he asserted here that Chief Justice Sereno alleged failure to truthfully disclose her...
Mr. Senate, can you please refer to the paragraph?
Yes, it's on charge 4.6 in the complaint, page 16, Mr. Chair. And on charge 6.3 of the complaint, page 36. On the disclosure of the statements of assets, liabilities, and net worth. It states here that what was not reported by the Chief Justice was the legal fees earned by the Chief Justice before she joined the judiciary. And specific to that, Mr. Chair, it seems that there's a contradiction, because in Gadon's own annex, it states that she earned 25 million pesos, or roughly around 580,000. But in the SALN, in the claim of Gadon, in a news report, he cited that the Chief Justice earned 745,000 or 37 million. So this precisely, Mr. Chair, why we would say that mere hearsay or without personal knowledge, this impeachment complaint should be supported by evidence and not by bare allegations of a news report. And secondly, citing this income that was derived prior to her appointment as judiciary, I don't think this would fall under the issue of her having falsified her statement of assets, liabilities, and net worth. And going beyond that, there are also other voluminous information in the charge sheet that I've read that only cited all newspaper clippings. I haven't seen the document submitted by the court last August 15. I have not read it, Mr. Chair, but I'm just using what was in the verified complaint filed by Attorney Gadon. So clearly, Mr. Chair, if we go by our rules, these are all mere hearsay evidence. So that's my point of objection, Mr. Chair.
Thank you for that. Of course, these are matters already that covers the issue on sufficiency in substance. But as to the documents, we have shown you already the originals in pink paper. And so with respect to form and with respect to the authenticity of those documents, perhaps we can already rule upon whether or not this matter are based or the complaint is based on authentic documents. No? So since we have heard the objections, we now recognize Vice Chairman.
Just 3 points. I will make myself very brief, Mr. Chair. Let it be known, and in fact emphasized, that the question of form was resolved in favor of Alejano, in Alejano versus Duterte. So I see no reason why some of our colleagues here will be citing the case of Alejano versus Duterte against the impeachment complaint we have now. Number two, the reason why I argued then that form be resolved in favor of Alejano was because of the ruling of the Supreme Court. It's about, you can come up with 100 decisions already since 1967 in the case of Oshita. More important was in the case of Villasanta 1970, where the Supreme Court said, doon sa verification that the same is true according to his own personal knowledge. The Supreme Court said in Villasanta versus Bautista, the court has consistently held that the reglementary phrase, quote, true to his own knowledge, unquote, is not a talismanic formula, the use of which would ensure the granting of the petition or non-use the denial of the petition. So that is the rule that has been consistently held by the Supreme Court. And for which reason, Mr. Chair, the Supreme Court, as I said, in over 100 cases now, held that verification is a mere formal requirement. It is not a jurisdictional requirement. So that in the recent case in my notes of Torres versus Specialized Packaging Development Corporation, July 6, 2004, the Supreme Court said, it is formal jurisdictional requirement. It is not fatal, and it cannot therefore affect this impeachment proceeding, Mr. Chair. Thank you.
Thank you. So we have heard the arguments and counter-arguments with respect to the sufficiency in form. I think the committee is ready to vote upon it, but we will just recognize one last comment coming from Congressman Lagman.
Mr. Chairman, on page 14 of the committee report with respect to the Alejano complaint, the Justice Committee resolved that, and I quote, the Alejano complaint, albeit defective, is sufficient in form. However, there was a caveat, as quoted by the distinguished chairman of the committee, and it said, this will be the last time the committee exercises liberality in finding defective complaints sufficient in form. So this time, we will have to be strictly enforcing the rule on sufficiency in form.
Thank you for that. Please rest assured that this committee will be strict in the application of the rule and of the precedent that we adopted in the Alejano complaint. And so the committee is now ready to vote on the sufficiency in form. So those in favor of...
Mr. Chairman, just
can you please let me finish? We are now in the period of voting. So those who are in favor of the complaint being sufficient in form, please rise. And Only the members, incidentally, please be reminded, only the members and the ex officio members can vote, can cast their vote.
Okay na? Okay. Ay. Sandali daw, sandali daw.
Tatlo yung counters natin.
30.
Tama? Okay, okay.
Those who are against the motion, please rise. Only the members are requested to. So, by a vote of 30 in favor of declaring the complaint sufficient in form, against a negative 4 votes, the complaint is hereby declared sufficient in form.
Mr. Chairman,
Please, Congressman Lagman.
before the voting, I was about to say that considering that there are so many charges pleaded in the impeachment complaint, we should have determined sufficiency in form not in the totality of the complaint, but per individual charge. But that is water under the bridge already, Mr. Chairman.
We take note of the observation of the Honorable Lagman. So, we now entertain a motion to determine the sufficiency of the complaint in terms of substance. We now recognize the Honorable Roque.
Mr. Chairman, thank you and good morning. Mr. Chairman, I move that we find sufficiency in substance on the first complaint that we have just voted upon on form, on the basis that the grounds stated herein constitute impeachable grounds if and when proven, either before the committee when we go to the substance or before the impeachment court in the Senate should we get there. But for now, it appears to me that all the grounds stated herein, including culpable violations of the Constitution, when the Chief Justice arrogated unto herself power pertaining to the court as a collegial body, as well as acts of corruption and other high crimes, including influencing a lower court judge in Muntinlupa to issue not to issue warrants of arrest against Senator Laila de Lima, and meeting the presiding justice and associate justices of the Court of Appeals and instructed them not to comply with processes of the House of Representatives, which is very close to our concern here in the House of Representatives, as well as failure to declare and pay the correct taxes on extortionate attorneys' fees constitute impeachable offenses. So I move that we find sufficiency in substance, Mr. Chairman.
Mr. Chair.
So, consistent with the previous rule adopted, may I see the hand of those who objected? The same four. So, we again start with siguro si
Mr. Chair, just a
Congressman
clarification.
Villarin muna. We will give you the floor. So, kayo na yan.
Just
You have your 3 minutes.
On the point of the process, Mr. Chair, because these are, I think, more than 20 complaints.
What do you mean 20
Charges.
complaints?
Charges.
Allegations.
So, yes. Can we have 3 minutes per allegation, Mr. Chair?
We follow the totality rule. Kasi ginamit na natin. So, you're now recognized with your 3 minutes, Congressman Villarin.
Well, Mr. Chair, again, as what was mentioned, the charges by Attorney Gadon And it summarizes here that there's culpable violation of the Constitution, corruption, other high crimes, and betrayal of public trust. So these are very grave and serious charges, Mr. Chair. But if we look at, again, the specific charges, one pertaining to charges from 4.4 to that of those occurring within the administration by the Supreme Court Chief Justice of the judiciary. First, I think these are matters that are pending before the Supreme Court and are internal to the court, and therefore outside the jurisdiction of the Justice Committee. So these charges pertaining to matters that are under deliberation, discussions in the Supreme Court are again outside the jurisdiction of the House Justice Committee. Now, on the specific charge, Mr. Chair, on the on charge 5.1, the purchase of a Toyota Land Cruiser, it states here that the court en banc, through its resolution dated March 28, 2017, it has approved, upon recommendation of the Supreme Court Bids and Awards Committee for Goods and Services, the award of the contract for the supply and delivery of a motor vehicle for the Supreme Court, amounting to 5,110,500 pesos. So in effect, this is a legal purchase and undertaken through the usual processes. Again, in the purchase of the Land Cruiser, it appears that this purchase, Mr. Chair, has again been approved by the Supreme Court en banc, and that said purchase cannot be considered illegal or impeachable. And on the third aspect, Mr. Chair, of my objection, on the alleged failure to truthfully disclose her statement of assets, liabilities, and net worth, it says here that failure to disclose attorney's fees and pay the appropriate taxes, which are again income derived before she joined the judiciary. Would it also be incumbent upon House members, for example, Mr. Chair, that prior to your being congressman, you will be asked to declare what was your income prior to your becoming a member of the House? So this allegations, these charges, Mr. Chair, again, would not fall under the impeachable offense for acts committed before she became Chief Justice or even Associate Justice of the Supreme Court. And again, on the issue of an impeachment complaint, again, it is my opinion, Mr. Chair, that this should be supported by evidence. And such evidences being submitted by complainant are basically documents submitted by the Supreme Court, and these Supreme Court documents, again, are matters of internal to the court and subject to the disposition of the court. Nowhere in the charges, Mr. Chair, that there are allegations that would fall under the four major
Please wind up.
the four major acts that would be impeachable offenses as enumerated in our Constitution. So, Mr. Chair, I would say that the evidences submitted are not substantial, beyond the jurisdiction of this committee, and thirdly, Mr. Chair, the specific charges have no evidence as submitted by the complainant. Thank you for that, Mr. Chair.
Thank you for that. Let me just remind everyone that the task of this committee is to end the process of impeachment is meant to really determine the fitness of a public official, an impeachable officer at that, to continue holding public office. So fitness is not something that is time-bound. So let us be mindful of the purpose and rationale of impeachment. So we now go to the next. Can we now recognize Congressman Lagman?
Thank you, Mr. Chairman. Because of the limited time, let me just cite certain portions of the complaint which will not stand sufficiency informed. Just in the totality, the entire complaint will not satisfy the stringent requirement of sufficiency in substance. Let me repeat this. In paragraph 6.3.1 of the complaint, Attorney Gadon stated that the subject legal fees were earned by the Chief Justice as counsel for the government of the Philippines in the Piatco case. This means that the fees were earned before, let me underscore, before she joined the judiciary. She cannot be impeached for acts committed before she became Chief Justice or even Associate Justice of the Supreme Court. With respect to charge 7.1, page 38 of the complaint, the alleged hiring of an information technology consultant without public bidding is without sufficiency because they were as close of the contracts marked as annexes 7.1-3, 7.1-4, 7.1-5, and 7.1-6 shows that direct negotiation was resorted to as an exception to public bidding under the Procurement Law, Republic Act 9184, because the IT consultant is a highly technical consultant. Now, the remaining charges 4.1, 4.2, 4.3, 4.5, 4.7, 4.8, 4.9, 4.10, and 7.7, even if true, appear at most to involve minor internal differences of opinion among the members of the Supreme Court or the JBC, which in the end were satisfactorily resolved. On their face, they are not even sufficient in substance to qualify as impeachable offenses. For all of these reasons, Mr. Chairman, I object with respect to the sufficiency in substance of the instant complaint.
Thank you, Congressman Lagman. We now recognize Congresswoman Bagao.
Thank you, Mr. Chair. I also object and I find the Gadon complaint insufficient in substance. Una po, doon sa 11 aligasyon ng culpable violation of the Constitution, ilan dito yung dito po sa in-enumerate niya sa complaint, siyam po sa aligasyon niya ni Attorney Gadon ay hindi po nagbanggit ng anumang provision ng konstitusyon na binayolate. So kung ang allegation ay culpable violation of the Constitution, kailangan may reference. Anong constitutional provision ang binayolate? So ano po yung mga allegation na walang reference sa anumang violation sa Constitution pero tinawag niya na culpable violation of the Constitution? 4.1. 4.1 falsification of SC resolution on AM number 12-1109. 4.2 falsified TRO of the Supreme Court in GR 206844-45. 4.3 falsified resolution of the Supreme Court in AM number 160804. 4.4 delayed action on numerous petitions for retirement benefits of justices and judges and the surviving spouses of deceased judges. 4.5, manipulated and delayed the resolution of request of DOJ Secretary to transfer Mauti cases outside Mindanao after realizing that she lost in the voting. 4.8, manipulated the JBC shortlist. 4.9, manipulated the shortlist of JBC for 2 vacancies in the SC. 4.10, lied and made it appear that several justices requested that they do away with voting for recommendees of the SC. 4.11, manipulated JBC, especially its 4 members, effectively destroying the JBC as a constitutional body. Lahat po ng aligasyon na ito ay wala pong reference sa anumang constitutional provision na na-violate, and yet ang ground po ay culpable violation of the Constitution. So paano po natin masasabi na ito ay sufficient in substance? Pangalawa po, doon po sa SALN, nakalagay po sa complaint ni Attorney Gado na dapat ay nireflect niya sa kanyang SALN nung siya ay na-appoint na Supreme Court Justice ang kanyang attorney's fees na pero paano niya, at ang gusto ni Attorney Gadon ay i-report ni Chief Justice ang kanyang income from attorney's fees na kinita niya bago 5 years bago pa man siya na-appoint na Supreme Court Justice. Ano pa bang nakalagay sa Republic Act 3019 that every public officer shall with isa-skip ko na lang po ang content ng batas. A true, detailed, and sworn statement of assets and liabilities, including a statement of the amounts of sources of the income, the amounts of his or personal and family expenses, and the amount of income taxes paid for the next preceding calendar year. Ang tinutukoy po ni Attorney Gadon ay income from attorney's fees na nakuha ni Chief Justice Sereno, matagal na, ilang taon na ang nakakaraan bago pa man siya naging Chief Justice at na-report na niya doon sa SALN ng taon preceding year kung saan siya ay dapat mag-report ng SALN na yun. So, dahil po sa mga ito ay tingin ko insufficient on substance ang complaint filed by Attorney Gadon.
Thank you, Congresswoman Bagao. We now recognize Congressman Zarate.
Thank you, Mr. Chair. Ganon din po ang ating paniniwala na ito ay hindi natupad yung requirement ng sufficiency in substance. No? Culpable violation of the Constitution, hindi ho simpleng ground ito, no? Na kahit ano na lamang ay isaksak natin dito sa complaint para lang matanggal ang isang impeachable official like the Supreme Court Justice, no? At tama ang natura ng ating mga kasamahan sa lahat ng mga allegations dito ay walang nabanggit anong particular na provision ng ating konstitusyon ang na-violate, no, ng Chief Justice. For example, ang sinabi lang ng Gadon complaint 4.8.6, all told, all the judicial maneuverings by Respondent Sereno shows her corrupt state of mind that makes her unfit to continue as the Chief Justice of the highest collegial court. So, is that a culpable violation of the Constitution? Again, sa kanyang allegation that Chief Justice Sereno manipulated the shortlist of the JBC. Ang kanya lang allegations dito, all hearsays, at sinabi niya, simply another clear case of culpable violation of the Constitution. What provision of the Constitution was violated? So, again, Mr. Chair, at marami pang dahil sa limitadong oras, malinaw dito na talagang we overstretch, no? Yung grounds na nakasaad sa ating saligang batas, paano ba para managot ang ating mga impeachable officials, no? At malinaw na ang kadahilanan bakit inihain ng impeachment complaint na ito ay ang naging tindig at tayo ng Supreme Court Justice, no? Ng Chief Justice na si Chief Justice Sereno. At kahit tignan mo yung ibang allegations doon, gaya na rin ng nasabi ng ating mga kasamahan dito, these are administrative matters. That some of these matters are still being considered by the Supreme Court, no? At bakit hindi natin bigyan ng pagkakataon ang Korte Suprema na based on their internal rules and procedures ay kung meron mang administrative lapses ay makorek ito, no? Dahil sa tingin ko, lahat naman ng ahensya ay nagkakaroon ng mga administrative lapses at pwedeng makorek ito without resorting to this proceeding like impeachment. No? So sa mga kadahilanan yan, Mr. Chair, no, ang kinatawang ito ay muli nag-o-object in finding sufficiency in substance at Gadon complaint.
Thank you, Congressman Sarate. Again, so we are now to consider yung sufficiency in substance of the Gadon complaint. And this is docketed as impeachment case number 002-2017. Ang importante po sa pag-consider nito ay yung merong recital of facts. If there is a recital of facts constituting the offense and merong nakalagay doon na yung kung ano yung mga grounds, and there are the grounds defined under the Constitution, culpable violation of the Constitution, yung isa ay corruption and other high crimes and betrayal of public trust as contained in the Gadon complaint, no? Pero ang pinaka-importante dito, yung recital of facts na yon would constitute or determine constitute the offense charge and will determine the jurisdiction of this committee.
Mr. Chairman.
But on a final note, tulad nung kaninang pinaliwanag ko, we have consistently followed the standard of individual appreciation by each member of the committee in determining whether a verified impeachment complaint is sufficient in substance. So, nasa sa judgment po ng bawat isa sa atin ang magiging boto natin, and that is what will matter. Kung ano man yung mapagbobotohan, the majority will prevail.
Mr. Chairman.
Sige po, one final comment on this from Congressman Legman.
Since there are multiplicity of charges and several grounds for impeachment, may I propose that in determining substance, we should do that per charge and per ground instead of a wholesale determination of the entire complaint.
Sabi ko nga po, ang papel po ng Committee on Justice as the initiator of the impeachment complaint is analogous to a fiscal, no, or a prosecutor. And a prosecutor would not want to limit itself to what is contained in the complaint, as in fact, the House of Representatives and the Committee on Justice, which is performing this constitutional mandate to initiate impeachment proceeding, is well endowed with the power to issue subpoena for purposes of strengthening the case so that when we bring the matter to the impeachment court, then we can present a very strong case. No? So at this juncture, I think we are now ready to vote upon the issue and for this committee to proceed with the voting on the sufficiency of substance of this complaint. So those who are
Mr.
in
Chair,
favor...
point of inquiry.
Point of inquiry. What is your point of inquiry?
Thank you, Mr. Chair. It is true, Mr. Chair, that we are still at this point. We will determine whether it is sufficient in substance or not. No? But just like the city prosecutor's office, when we see a complaint, and if the complaint is actually without clear basis, the prosecutor can outrightly dismiss such a complaint. For example, Mr. Chair, there is clear...
we are not yet in the determination of probable cause. This is just the complaint, and we will go into that next step after we ruled upon this complaint in terms of form and substance. So darating po tayo dyan. And tulad nung sinabi nyo, pag pasasagutin natin at pag napasagot natin, let the assuming we will vote upon the sufficiency of substance, let the respondent herself explain to us why this complaint fails in terms of the acts therein constituting probable cause. Very short. Sige.
Yeah. Mr. Chairman, very short manifestation. It is clearly said in Rule 3, Section A, that the requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. So it is very clearly stated in this rule, Mr. Chairman.
Anyway, at the end of the day, this will all be based on the sound judgment of each and every member of this committee. So, for those who are in favor of finding this complaint sufficient in substance, please rise. For those who are against the motion, please rise. With a vote of 30 in favor of declaring the complaint sufficient in substance against a vote, 4 votes against it, the chair hereby declares this complaint to be sufficient in substance. So we will now proceed with the impeachment case number 003-2017, and the COMSEC is hereby requested to read the title of the complaint.
Impeachment case number 003-2017, Dante L. Jimenez, Founding Chairman, President, Volunteers Against Crime and Corruption, and Attorney Eligio P. Mariari, President, Vanguard of the Philippine Constitution Incorporated, complainants, versus Supreme Court Chief Justice Maria Lourdes P.A. Sereno, respondent, verified complaint for impeachment.
Okay, so this complaint, saan yung coverage ito? This complaint covers 2 grounds: culpable violation of the Constitution with 4 allegations contained therein, and another ground of betrayal of public trust with alleging 2 acts constituting betrayal of public trust. So we now request Congressman Art Defensor to make his motion, and you have the floor.
Good morning, Mr. Chairman. Good morning, ladies and gentlemen. I'm one of the endorsers of this of 003-17. The endorsement is a preliminary finding that the complaint, as filed, is sufficient in form and substance, as stated in our resolution of endorsement, that we, the undersigned have examined the above-mentioned verified complaint for impeachment and found that the same to be sufficient in form and substance. Now, is it sufficient in form? Yes, Mr. Chairman, because the rules require that the complaint should be verified. Is the complaint verified? Yes, it is verified, Mr. Chairman. Let me go to the complaint. The complaint is verified by the complainants, Mr. Dante Jimenez and Attorney Elio Malyari, and it states in this manner: we, Dante Jimenez and Attorney Elio Malyari, under oath, state that we are the complainants in the above entitled verified complaint for impeachment, that we have caused the complaint to be prepared and have read the contents thereof, and that the allegations therein are true of our knowledge and belief, on the basis of our reading and appreciation of documents and other records pertinent thereto. Is this a correct verification? Yes, it is, Mr. Chairman. It is honest and accurate because it totally corresponds to the degree of knowledge possessed by the complainants when they wrote and filed this complaint. Is it sufficient in substance? Yes, it is, because the rules require that it must contain a recital of the facts that would confer jurisdiction upon the Committee on Justice without going outside the four corners of the complaint, just by mere reading of the recital. So, is the complaint sufficient in form and substance? Yes, it is, Mr. Chairman. And I would like to move for that the committee finds this complaint sufficient in form and substance. I so move, Mr. Chairman.
Second.
Yes. First, let me limit the motion because we are still in form. Let me limit my motion to sufficiency in form only, Mr. Chairman.
There is a motion. Any second?
Second.
It has been moved and seconded.
Objection.
There is an objection. May I
Mr. Chair.
see the hand of those who objected? 1, 2, 3, 4. Pareho pa rin, ano?
Mr. Chair,
Yes,
before
Vice Chair.
those who
Omina.
object will present their respective position. This chair would like to ask clarification insofar as the verification, the format and the wordings of the verification in this complaint, because it really differs with that of the Gadon complaints. And in the Gadon complaints, this humble representation voted for the sufficiency in form because all the doubts that I have were properly clarified, especially so when the majority leader had presented the resolution of the Supreme Court supporting the authenticity of the documents attached in the complaint. And as a backgrounder, Mr. Chair, beyond as can be gleaned in the records, that in the impeachment complaint against the President, I was the one who sponsored for the motion in sufficiency in form and invoking liberality with the caveat there that in the next impeachment complaint, there must be that standard of a standard that will be observed by this committee. Now, what is the difference, Mr. Chair, is that in the Gadong complaints, it specifies that it is based on the personal knowledge and or authentic documents or public documents. And in this case of the VECC complaint, it only alleges that these are true of their own knowledge and belief on the basis of their reading and appreciation of documents and other records pertinent thereto. It does not speak of their personal knowledge, but on the basis of their reading and appreciation of the documents. It does not also speak on authentic documents, but just say other records pertinent thereto. Whether or not these allegations in the verifications conform within our standards, because while it is true that in the attachment therein, those documents which were also attached in the Gadon's complaint, duly certified, are also being attached in this complaint, but I am just bringing to this committee whether or not these allegations in this kind of formalities falls within the standard set forth by this committee. Thank you, Mr. Chair.
Thank you. We will ask the endorser, Congressman Art Defensor. But from the records that I reviewed, I see a certified true copy, a stamp marking certified true copy, certified to by Attorney Anama of the Supreme Court. And so, and the originals are also with the committee. So again, similar to the earlier situation where we showed the pink copies thereof, in this particular case, there is now a certification coming from the authorized certifying officer, who is the clerk of court of the Supreme Court in the person of Felipa Anama. So, having said that, may I request Art to further clarify this matter, because I believe that before you endorsed, you were shown these copies, and this should have, and you acceded to endorsing this by reason thereof.
Yes, Mr. Chairman, the gentleman is correct. This complaint is not verified in the same manner that complaints under the rules of court or other impeachment complaints may be verified. Is it verified? Yes. Is it a kind of verification that the committee or the rules of court would customarily require in the manner that it is stated? That is another matter. Can it be accepted by the committee? Of course, it is another matter, and we will leave it to the wisdom of the committee. But can the committee require a verification that will state the impossible? No. Because under the circumstances, Mr. Chairman, there is no way that such complainants can have stated that they have personal knowledge, that it is based on personal knowledge, in the manner that they were there when it happened. You're physically there and you noticed things transpire, you noticed events happen, and transactions being undertaken. You cannot do that by the circumstances of the complainants. But is it an accurate reflection of the degree of knowledge possessed by the complainants? Yes. And there is no way, again, that they could have stated honestly and accurately the phrase personal knowledge in this verification. And they're correct. Their knowledge is based on the documents that they have attached. And do you have reason to doubt these documents? No, because these documents are official documents, Mr. Chairman. So, yes, it is correct. This is not the customary verification that you would want it to be. But is it the correct, accurate, honest verification that under the circumstances, a complainant of their nature could have executed? So on that score, Mr. Chairman, that is the reason why that in endorsing, which is merely limited to a primarily determination of whether is the complaint sufficient in form and substance, the answer is yes, Mr. Chairman.
Thank you, Kong Art. Anyway, what is controlling is that that the document is culled from authentic documents. So if we will refer to the documents, and for the record, let me just go through this. Annex A of the complaint contains a certification that this is a certified true copy signed by Felipa B. Anama, Clerk of Court and Bank Supreme Court. Annex B was equally certified, similarly certified by Attorney Anama. Annex C was certified by Antonio Y. Ocampo Jr., SC, Supervising Judicial Staff Officer, Personal Division, Office of Administrative Service. Annex D, also certified by Antonio Ocampo. Annex E by Antonio Ocampo. Annex F by Attorney Anama. Annex G by Ocampo. Annex H by... Yan, ito wala, no? And I, wala rin. J, meron ba J? So wala rin yung J, no? So some are certified, the others are not. But then again, as I said, what is controlling is that there are authentic documents from which or that would be the basis for the allegations contained in the complaint. And the complaint, we look at it on a totality basis for purposes of determining sufficiency in form. So,
Mr. Chair, clarificatory question lang po. May tanong po ako.
Mr. Chair, before that, may I finish with my clarification,
Di
Mr.
ba ba?
Chair? Di ba? So, do I mean to understand, Mr. Chair, that what is controlling now is not in the language of the verification, but on the attachment, the attached documents in the complaint?
That it is based, it's called from authentic documents. Yun ang importante, okay. Authentic documents, because ultimately that is what will prove that particular fact.
Even those authentic documents are not mentioned in the verification. Thank you very much, Mr. Chair.
Let me just...
Verification?
On a similar issue?
On a similar issue, Mr. Chair. Though the verification in the complaint of the VACC is not in the form contemplated...
Wait. DOVACC ito, ah? In their personal capacity.
In their personal capacity, Mr. Chair. But in the case decided by the Supreme Court in Fernandez versus Villegas, GR number 200191, it states that verification is deemed substantially complied with when one who has ample knowledge to swear to the truth of the allegations in the complaint or petition signs the verification, and when matters alleged in the petition have been made in good faith or are true and correct. Clearly, Mr. Chair, the affiant has ample knowledge and swear based on their knowledge of an authentic record issued by a public officer in the person of what you have stated earlier.
Thank you. Noted. And so,
Mr. Chair,
we will just entertain one final comment from
just question.
Congressman Kaka.
Thank you, Mr. Chair. Ang question ko lang po ay, sino po ang notarize ng verified complaint na ni Dante Jimenez at Attorney Elicio Mamarin?
The records will show it is the Secretary General, Cesar Pareja, Attorney Pareja.
So I will just explain my objection, why I'm objecting to the sufficiency in form because of that.
Okay na, Art? One final point?
And just to add, Mr. Chairman, the verification of this complaint is likewise called in the language of our own rules, because under the rules of impeachment, which is in section 13, Rule 4, whenever we file an impeachment directly, the one which we send directly to the Senate for trial with a 1/3 vote or signature, this is the required format of the verification. We, after being sworn in accordance with law, post and state that we are the complainants in the above entitled complaint, resolution of impeachment, that we have caused the said complaint or resolution to be prepared and have read the contents thereof, and that the allegations therein are true of our own knowledge and belief on the basis of our reading and appreciation of documents and other records pertinent thereto. Meaning, the language of this verification is sourced from our own rules. Thank you, Mr. Chairman.
Mr. Chairman.
Thank you. May we now recognize the Chair of the Committee on Rules to clarify this so as not to
Yes,
mislead.
as Chair of the Committee on Rules, the rule cited by the gentleman from Iloilo applies if you read the heading, Rule 4, verified complaint resolution by 1/3 of members. So if it's 1/3 of members, you can use that kind of a verification. But not for complainants. Complainants, this rule applies only when the complainants are 1/3. Because it would be impossible for 1/3 of the members of the House to have personal knowledge of all of these things. So based on belief, based on that's why the rule says here that you just read, huwag niyo pong kopyahin ito. When you file a complaint for impeachment, do not copy this provision because this applies only when it is filed by 1/3 of the members. Para lang po guidance in the future. Very clear po eh. This is under Rule 4. The heading and title is Verified Complaint / Resolution by 1/3 of members. So when there is a complainant, you follow yung proper verification.
Thank you for that clarification. Can we now proceed with the vote?
Let's explain first.
Kasi wala nang objection. So we will now divide the House. Di pa ba na-explain? Nag-explain na kayo. Oh, we start with... Mahirap. Kong Kaloy, please.
Thank you, Mr. Chair. I objected, Mr. Chair, because very clear in the verification, and we thank the majority leader for clarifying this, because very clear the verification used here is different. This is a verification for a resolution or an article of impeachment. So, gusto ko lang ibalik doon sa sinabi natin sa Alejano complaint. No? Maging stricto na tayo, Mr. Chair. Huwag tayong maging liberal dito. At kung babasahin mo ang verification, talagang improper yung verification. There was no statement that this complaint is based on personal knowledge, and that is not just a simple requirement that is based on personal knowledge. In the case of Negros Oriental Planters Association Incorporated versus the presiding judge of Negros Occidental, 595 Philippine Reports 1158, year 2008. It states here, Mr. Chair, and I quote, clearly, the amendment was introduced in order, meaning the amendment of inserting the word personal, was introduced in order to make the verification requirements stricter, such that the party cannot now merely state under oath that he believes the statement made in the pleading. He cannot even merely state under oath that he has knowledge that such statements are true and correct. His knowledge must be specifically alleged under oath to be either personal knowledge or at least based on authentic records. No? So if we examine the verification here, Mr. Chair, hindi lang base sa personal knowledge, walang personal knowledge, there was even no mention that all of these allegations here are based on authentic records. What was stated here is they read and appreciate documents and other records pertinent thereto. There was no statement that it is based on authentic records. So based on those grounds, Mr. Chair, I object to the finding of sufficiency in form in the complaint of Mr. Jimenez and Attorney Malyari. Thank you, Mr. Chair.
Mr. Chair.
Congresswoman Bagaw.
Mr. Chair, I would like to explain my objection. The requirement that is set by the rules of the House is the filing of a verified complaint by any citizen upon a resolution of endorsement. This is not a verified complaint and not compliant to the required verified complaint cited in our rules. Because what the complainant did was to verify the complainant using the rule applicable to the members of the House. The Secretary General cannot notarize a complaint that is filed by a private complainant as stated in our rules. So I say this does not comply with the requirement as to form because we are not dealing with a verified complaint. So I object, Mr. Chair.
Congressman Lagman.
Mr. Chairman, I will not anymore belabor my explanation of my objection. Considering the statements, particularly coming from the leadership of the majority, I will just wait for the expected and inevitable result. Thank you, Mr. Chairman.
Thank you. Thank you, Congressman Lagman. Congressman Villarin.
Mr. Chair, I second the motion of the esteemed Congressman Ed Lagman, the former chair of the Justice Committee of the House. And
You mean
is
second the
well-versed.
objection?
I second the objection.
Actually, you are the fourth objector already.
No.
So you
I
fourth the
second the
objection.
observations, Mr. Chair.
Mr. Chairman,
Yes, Majority Leader.
with deep regrets and happily for the four, I join them in their objection because I have to be consistent and the committee has to be consistent because we gave a caveat last time that all complainants are warned that when they come here, they should follow the proper form. While indeed there are other documents, but their form is very clear po kasi under the rules of court. Ang sabi po ng rules of court with this kind of a pleading, ito po, Section 4, verification. A pleading required to be verified. Ito rin po yung sinabi ko doon kay Representative Alejano, which contains a verification based on open quotation marks, information and belief, which is what appears here, and correct of his or lacks or upon knowledge, information, and belief, quotation mark, or lacks a proper verification, shall be treated as an unsigned pleading. So, mali po kasi yung verification na ginamit nyo eh. Kinupya po nyo yung verification pagka 1/3 of members. Having said that, I wish also to disagree with Representative Bacau. The Secretary General can administer the oath even if not filed by 1/3 of the members as an administering official authorized to. Maski po, private complainant, pag pupunta dyan, gusto niyang panumpaan yung verification na kay Secretary General, pwede rin po yun. Hindi po bawal si Secretary General mag-administer ng oath because that is his duty. But I object simply because to be consistent with our earlier statement of caveat, dapat po sinusunod natin yung form natin on verification. So I also register my objection that we'll vote accordingly, Mr. Chair.
Thank you for that clarification.
Mr. Chair, with that, Mr. Chair, I am now converting my manifestation
Mr.
earlier
Chair.
made as an objection to the motion.
Mr. Chair. Mr. Chair.
Noted.
Mr. Chair.
Congressman Veloso, Vice Chair Veloso.
Two things. As was in the case of Alejano versus Duterte, I disagreed with my boss, the majority floor leader, on this point. And I will reiterate this adverse position. Number one, when you speak about personal knowledge, you're talking about hearsay. When you talk about hearsay, it is not proper at this stage. It is proper only at the stage of hearing, which is in Section 6 of our rules. If we have to abide by the position taken by the majority floor leader, Mr. Chair, then we have to amend our rules. Section 2 of our rules only says, the complaint must be verified. It has been verified. And it has to be endorsed, it has been endorsed. On the matter of whether or not it is true and correct, this is something that has to be deliberated upon come hearing. But before we reach that stage, Mr. Chair, we will have to require the respondent to answer. And remember that in Section 5 of our rules, it says the respondent cannot even move to dismiss the complaint. If the respondent cannot even move to dismiss the complaint, who are we in the committee to reject the complaint?
That is our duty.
And then That is
We
precisely
are
my point.
the authority on that.
And my last point, precisely, because remember that we are still in form. In Alejano, after we disagreed here, we went into a caucus. And when we came back, we all agreed that the Alejano complaint must be admitted as substantially compliant with our rules. I submit, Mr. Chair, that the verified complaint of VACC is substantially compliant with our rules. I so submit. And besides, if we have to amend our rules, we have to amend. It's not on the plain say so. Remember that we are passing figures here. What we did in Alejano could happen next, 18th Congress. Or it may not even happen at all. Please amend our rules, and until after we have amended our rules, let us comply with the rules. And the rules says, Section 2B, it should only be verified, endorsed. No more, no less. It has been verified, and it has been endorsed. Thank you, Mr. Chair.
Thank you.
May I just be allowed to rejoin because the gentleman mentioned my name as the chairman of the Committee on Rules. Sir, our committee report, which was approved by plenary, ito po, this is, it was already read by Manong its Representative Lagman earlier, but this is committee report number 257, which was adopted by plenary. After several, ito po, page 13, line 23. After several arguments for and against the motion, the chairman declared an executive session to discuss the matter, which the gentleman referred to. Upon the end of the executive session, Representative Uaminal restated his motion to find the complaint sufficient in form, while Representative Fariñas amended the motion by adding that this will be the last time that the committee exercises liberality in finding defective complaints sufficient in form. So, defective, hindi po tama yung form, because we're talking of form now. The gentleman said, who are we? We are the ones who really decide on this. The respondent cannot move for, but this committee, and as member, and as laid down by the chairman, we are guided by our individual conscience here. Who are we? We are the elected representatives of the Filipino people to determine whether it is sufficient in form, and that is our rule. So, based on my reading, it is not sufficient in form. Yun lang po.
One last point lang, Mr. Chair. It is good that my boss, the majority floor leader, emphasized that we have independent say. Now, this is not a case being decided by the judiciary, where, especially by the Supreme Court, where the decision of the Supreme Court constitutes the law in the matter. Each impeachment complaint will become a separate case. Kung nasa judiciary pa yung pro hac vice, yung dati natin. Now, I am just appealing to my colleagues that, remember, we have a provision here, and in fact, this has been affirmed in the case of Oshita on verification, 1967 ruling. In the light of what the Honorable Defensor said, the Supreme Court in Oshita versus Republic, 19 Escra 700, 1967, it said, if the verification is lacking, or the complainant did not submit a pleading that is verified, the court can act on the pleading although it is not verified if, I will underscore, the attending circumstances are such that the strict compliance with the rule may be dispensed with in order that the ends of justice or the rule of law may be served. The Honorable Defensor said, how can these complainants come up with certified true copies when it is difficult to come up with a certified true copy from the Supreme Court. And number two, how can they have personal knowledge on the corrupt activities allegedly committed by the respondent when they are not privy to it? These circumstances, Mr. Chair, would dictate that we please allow the impeachment complaint of the VACC to proceed, being proper informed, as held in Oshita versus Republic, a 1967 ruling. Thank you, Mr. Chair.
Thank you for that,
Mr.
Vice Chair.
Mr. Chair.
Dumami. Okay, we will extend the liberality of this committee in allowing more members to talk. We promise that we will extensively discuss this. Congressman Salo is recognized.
Thank you very much, Mr. Chair. I respectfully register also my objection to the particular verification that was attached to this complaint. I echo the comments made by the Majority Leader a while ago that this particular verification was copied and is not applicable to this particular complaint, this specific particular complaint. Number two, if you will note also, it is mentioned here through of our own knowledge and belief. Of course, the verification, in as much as the rules of court is suppletory to this particular verification, then it should have been either personal knowledge or on the basis of authentic records or documents. The way it was stated here, and I suppose just wondering why it was difficult, why it was difficult for the complainants to just follow the form that has been prescribed by the rules of court. Thank you very much, Mr. Chair.
Thank you. We now recognize Congressman Gonzaga.
Thank you, Mr. Chair. We have a rules on the impeachment proceedings. Rule 2 provides the mode of initiating impeachment. There is a verified complaint. Now, how are we going to make a complaint verified? The rules did not say how to make a verified complaint. So we will relate this to the rules of court. We go to Rule 7, Section 4, as read by Honorable Garvin earlier. So that rule provides that there will be a verified complaint if the affiant has read the pleading and that the allegations therein are true and correct of his personal knowledge or based on authentic records. There are two, personal knowledge or based on authentic records. The Alejano case. The Alejano case failed to pass the as to form because Alejano has no personal knowledge. And at the same time, there is no certified true copy or authentic records. So therefore, Alejano complaint must fail. This case of Gadon. Gadon has no personal knowledge. We know that. But there is authentic records. That is because he asked the Supreme Court to provide for authentic records. Therefore, he passed the test of as to form. With regard to this Dante Jimenez and the Malyari case, Attorney Malyari complaint. Now the opinion is it fails the test as to form. I disagree. Why? Of course, there is no personal knowledge. But as to the appendix or the attachment, all of the records, if not all, are certified true copies and authentic. Therefore, it passes the test as provided for under Rule 7, Section 4, because it is suppletory in nature to our rules in the impeachment proceedings. So with regard to that, Mr. Chair, I submit that there is substantial compliance as to the verification. Thank you, Mr. Chair.
We now recognize Congressman De Vera.
Thank you, Mr. Chairman. You will look at the record that I was the lone dissenter during the time that the form was issued, the form was discussed during the impeachment complaint versus President Duterte. When we discussed the form, I objected to it, for it was not really, it was not informed. we have already decided, and it was reported out in the plenary, and it was already approved. So what do I mean? It was already noticed to everyone. When you file a complaint in the House of Representatives, see to it that your complaint is in accordance of what we have agreed upon here in the House of Representatives. Kaya nga po nung ngayon, meron na namang ganyang insidente. We have already issued a caveat. Kaya to all complainants, please study your lessons, do your homework before filing an impeachment complaint.
Thank you.
Short rejoinder, sir.
Before that, si Harry,
Thank you, Mr. Chairman. Mr. Chairman, the problem is, while we have prescribed for a specific form of verification under Rule 4 for verified complaints to be filed by 1/3 of members of the House, we did not expressly provide in our rules of impeachment the specific language of the verification where there is an ordinary complainant filing it. And that is why, even if the committee may have agreed, we agreed on the rules of impeachment proceedings at plenary. And that is why I think complainants should not be made to suffer the consequence for our own lapse. Because while we insisted on a specific form when it is filed by 1/3 of the members of the House, we did not provide the form that is required for all other complainants not involving members of the House. And that is why not only do I seek liberality, but I also ask indulgence of the members of this committee that unless and until we have agreed to an amendment of these rules at plenary, I do not think we could insist on a specific form, and in default thereof, we could apply the general language of the verification required even by our courts. I understand about what the committee has agreed on the earlier case of the impeachment complaint against President Duterte. But had we insisted on that specific language, we should have also amended the rules at plenary if we want to bind all other future complainants to the language of, to a specific language of the verification that we will be requiring. Thank you, Mr. Chairman.
thank you. Majority.
Because I was alluded to there that we blame the House. I was the one who wrote the rules in the 15th and in the 16th. You know, Your Honors, you do not prescribe anymore the form for affidavits. Do not put that in the rules anymore because everybody should know how to make a jurat. You do not provide anymore for the form as to verification because everybody should know how to verify a document. But this, for 1/3, is precisely there because it demands a lesser verification. Because these are already, the complainants here are 1/3 of the members. It would be impossible for 1/3 of the members, for example, if there's public knowledge that this impeachable official is already getting crazy or committing murder, that he is already not suited for the office, then 1/3 of the members can immediately file and direct the case. So you require a lesser degree of verification based on belief. Pwede. Dahil 1/3 nga eh. Can you imagine 1/3 of all the members? But if a complainant comes to the House as a private citizen or as a member complainant, he should comply with verification requirements. So we cannot provide for all the forms. Otherwise, magiging legal forms. I know why Harry is objecting because that is the form he adopted in his complaint against Bautista. Kinopya nila yung... I know because I read already the document. So I know where you're coming from, sir. Because they copied, in fact, for the record, I chided the Secretary General, why is this the kind of form? Yan po yung, that's what they did. Can you read the heading? This form applies if the complainants constitute 1/3 of the members of the House. But if the complainant himself is alone, then he should, how to verify a document? As lawyers, we know already how to. We cannot provide all the forms kung this is how a URAT should be made, this is how a verification should be made. Magiging rules of court na yung ating rules of procedure. So, alam na natin yung procedure yan. So, just to answer, kasi nga, binibintangan mo na kasalanan ng house yan. Hindi ko na kasalanan na. Hindi na namin. Kasi magiging legal forms 101 tayo. Put all the forms for...
One last point,
Mr. Chairman.
Mr. Chair.
Mr. Chairman.
Si Kong Doy Diacho, lumami, oh.
Yes, just to supplant the comments of the majority leader. Well, number one, Mr. Chair, I would like to agree with our majority leader. Number one, the jurat should not be contained in the rules of impeachment, considering that by nature, we should know under the 1997 rules of civil procedure that it should be supplementary to the rules of impeachment in this case. Number two, there is a specific provision in the rules of impeachment regarding endorsement by 1/3 members of the House. Number three, as excellently remarked by Congressman Lagman in his earlier objection, there was the committee report regarding the adherence, once and for all, to the strictness of appreciation as to the form. Number four, after all, as intelligently enunciated by our chairman, it is the individual appreciation of each member on how to deal with the sufficiency in form. And lastly, but not the least, I think the issue is quite immaterial in the sense that, after all, this is only as to form. If there's a mistake as to form, it can be just returned back to the SecGen for the rectification of the same. I think at this moment in time, Mr. Chair, would like again to reiterate the motion to divide the House or to move for us, if there is already an earlier motion, to reiterate the votation on said motion, Mr. Chair. Thank you.
Thank you for that. Alam nyo, before that, tuwan-tuwa si Congressman Lagman. Si Manong Edsel, tuwan-tuwa. Nagkagulo yung majority. Ayaw na nga niya magsalita kasi ine-expect niya, expected na niya, natapos na kagad to. Pero naiba ang direksyon. Kanya, anyway, this is democracy at work, and this is for the people viewing this proceeding to witness themselves now how we work in Congress. So, merong point of order ba? Wala na. Okay, so
Mr. Chair,
there is now a motion.
Point of inquiry.
Point of inquiry. What is the point of inquiry?
It was stated a while ago that our rules are deemed supplemented by the rules of court. But looking at our rules of court, Mr. Chair, it says in section 16, rules of procedure, the rules of criminal procedure under the rules of court shall, as far as practicable, apply to impeachment proceedings before the House. It is the rules, or collectively, it is the rules of criminal procedure that has been suppletorily adopted. Now, looking at the rules of criminal procedure starting from Rule 110, nowhere do we find any verification requirement in the manner that is required and that has been discussed in our proceedings today. It says the complaint or information in Section 2, Rule 110, shall be in writing. Wala. Well, anyway, yun na lang po. Salamat po.
Okay, so...
Kasi po yung verification nasa Constitution po yan sa impeachment. Yung rules of criminal procedure, hindi ko talaga verified ang complaint.
Let us remind everyone that impeachment proceeding is sui generis. Yeah. And kanina nga, I have always emphasized many times over that the standard to be followed is the individual appreciation by each member of the committee in determining whether a verified impeachment complaint is either sufficient in form and substance. ultimately, it is the majority that will decide, and I guess at this point in time, we are ready to divide the House. There is a motion, and there is an objection, and so we will divide the House. Those who are in favor of determining of the motion that to find the complaint sufficient in form, please rise. Buti na lang, hindi ako bumoboto.
Pahala tayo po sa chair.
So, those who are against the motion, please rise. No. Ilan. Nabaliktad, 4. 30 na uli yun. With a vote of 5 in favor of the motion and 28 against the motion, the democracy won, and so the complaint is deemed insufficient in form and therefore dismissed for the same reason. Okay. So for our final disposition, may I now refer everyone to Section 5 of Rule 3 on the finding of probable cause. Section 5 provides, and I quote, notice to respondents and time to plead. If the committee finds the complaint sufficient in form and substance, and we did that in impeachment case number 002-2017, the committee shall immediately furnish the respondent with a copy of the resolution and or verified complaint, as the case may be, with written notice that the respondent shall answer the complaint within 10 days from receipt of said notice and serve a copy of the answer to the complainant. No motion to dismiss shall be allowed within the period to answer the complaint. So 10 days from today, we will announce the next hearing after the respondent, Chief Justice Maria Lourdes Sereno, has filed her answer after she has received a copy of the complaint of Attorney Gadon for her to answer within a period of 10 working or calendar days, hindi session days daw para ho malinaw. So that will be more than a week from now. So we will announce the schedule for the hearing on the matter for us to be able to extensively discuss the matter and vote upon on whether or not the complaint, which was found sufficient in form and substance, has probable cause to continue with the formulation and preparation of the articles of impeachment. So that will be the next stage of this impeachment proceeding. Maraming salamat po. And
I move to adjourn, Mr. Chair.
on that note, the favorite motion has been made.
To adjourn.
This proceeding is hereby adjourned.
Yan po naging pagdinig ng Committee on Justice ng mababang kapulungan ng Kongreso kung saan tinalakay ang dalawang impeachment complaint laban kay Chief Justice Sereno. At base sa naging botohan ay sufficient in form and substance ang inihain na complaint ni Atty. Gadon habang hindi naman pumasa sa panuntunan ang inihain na impeachment complaint ni Dante Jimenez.